Good evening, everyone. My name is Arinda. I am an associate in our corporate, commercial, and our technology law departments. So I'm going to speak to you about the basics of intellectual property and specifically copyright law. As you can imagine, this is quite a broad topic, but we are going to limit it tonight to the art world, to what is applicable to for your purposes. When I normally deal in my daily work with copyright or intellectual property, it's more in the sense of software law, it's more trademarks. We don't really deal with copyright and art. So that's why we're going to talk about basics, because the basics applies to everyone. So when we talk about intellectual property, we are essentially talking about creations of the mind, inventions, written work, artwork, software, computer programs, anything that is created by the mind. And in South Africa, we have 4 main types of intellectual property, of which the one I'm going to be focusing on tonight is copyright, because that is relevant for you. The others are patents, which protects inventions or discoveries, which might also be relevant to you in some sense. There's a lot of rules and regulations regarding registering patents. Then we also have trademarks, which is normally when you trademark a logo or brand name or slogan to identify certain goods or services, which might also be relevant to you if you want to trademark your logo or your brand name. And then we also have trade secrets, which is essentially the protection of a business's confidential information. So when we jump into copyright, it's regulated by the Copyright Act, and there are various types of work that are copyrightable. And that includes literary works, it includes artworks, it includes music, sound recordings, computer programs, software, inventions, a lot of different things. And when we talk about literary works in terms of the Act, that is all types of written work. So novels, books, poetry, speeches, articles, any type of written work falls under literary works. And then artworks would cover paintings, drawings, sculptures, photographs, all of that falls under artworks. Unlike the other types of intellectual property, copyright doesn't need to physically be registered for you to have the protection. It is an automatic right that attaches to the creator or the author of the work. But there are 2 requirements, and this is very important. Everything is not always copyrightable just because you created it. It needs to be original. So there needs to be a certain level of effort, skill, and time that goes into creating this original work. That's when it becomes original. So what we call sweat of the brow. You actually need to do something to create it. And secondly, it needs to be in material form. Ideas are not copyrightable, no matter how brilliant they are. It needs to be in a material form. So whether that means in writing, record it, if you are putting a paintbrush to a canvas, whether you are saving it either on your digital camera or on your computer, your digital art form, it needs to be material form for it to be protected. So there is copyright is not always black and white. There is a gray area. There's different interpretations of when something is copyrightable, when it is enforceable. A simple example that I've recently dealt with, it's not specifically art related, but if you create a recipe, you're a chef, you create a recipe for chicken. That recipe is not really copyrightable. You might think it is the most brilliant chicken that you've ever created. No one will do a chicken better. The recipe, I'm going to use that recipe and I'm going to make the same chicken. That doesn't mean I'm infringing on your copyright. I can, if you said I must put in salt first and pepper second, if I put pepper in first and salt second, that's my recipe now. You don't have the copyright in that. So the moment I put that recipe in a cookbook and I put a nice picture of my chicken, my brilliant chicken, and I put it in a certain format, I have copyright in that. I own that. Someone can't copy that page and use it for something else or put it in their own cookbook. So that's why I'm like, copyright there is a gray area in it, and there is a lot of interpretation. And the problem with it is our law is still evolving in that. That's why we are trying to get the Copyright Amendment Bill through Parliament, but it's ever evolving, and our case law is not that great on it. It hasn't been tested as much, especially in this field. So when we talk about copyright, if I say you have copyright, what does that mean? Essentially, it means you have a list of exclusive rights as the copyright owner. You have the exclusive right to reproduce your work, to adapt your work, to copy your work, publish it, translate it, put it in a film or a broadcast or television. All of those rights are exclusive to you as the copyright holder. If someone else comes and tries and adapts your work or changes it, that is a copyright infringement. And when we use the word adapt, it's very important in terms of the act. Adapt means if you take the work and you transform it in a way where the original or substantial features of the original remain recognizable, then that's a copyright infringement. So we're going to talk about that a little bit later, but it's a very important aspect that you need to grasp when we talk about copyright law. There are exceptions, which we call fair dealing. For example, if someone uses your work for personal use, for research, for teaching purposes, criticism on your work, just quoting your work, all of that would not be considered copyright infringement. It's fair dealing. So a few examples, if a movie is shot in a street where your massive graffiti art is in the background, not incidental to the movie, that's not a copyright infringement. The movie doesn't need your permission. They didn't need to tell you about it, and they don't need to pay you for it. If you are exhibiting your art in a gallery, the gallery wants to print flyers with your artwork on it to show that your art is there. That's not a copyright infringement. They don't need your permission. They have an implied license for that. If a lecturer quotes a piece of your written work in a lecture, that's fair dealing. It's not an infringement. But again, gray area. If I come to an exhibit where your work is, whether that's in a gallery or in public, and I take a photo, that means I'm copying it. I'm copying your work by taking a photo. But now I put that photo as the background to my phone because your artwork is so brilliant. That's my personal use. I'm using it just for my personal use. So fair dealing, not copyright infringement. The moment I post it to social media and I don't tag you, that's a copyright infringement. I can't do anything with that photo that I'm not allowed to because I'm not the copyright owner. I can't copy it, I can't adapt it, I can't put little things on it and post it to my own social media. I can't do anything with it except personal use. But where do we draw the line with personal use? So that's what I said. It's not always black and white. It's up to interpretation sometimes and how you actually enforce the copyright. Copyright duration is for as long as the author or the creator lives, plus 50 years. Or 50 years from the date of the first publication of the work, whichever is longer. For photographs specifically, it's 50 years from the end of the year in which the photograph was first publicized, the first time the public saw it. When we talk about copyright ownership, we also need to mention if you are in an employee relationship or if someone commissions you to do the work. Peter's already explained to you what it means to be an employee. If you are creating work as an employee for an employer, whether that's an individual or a company, that employer will automatically own the copyright in whatever works you create. If someone commissions you specifically for photography or to draw or paint a portrait, the act is very specific here, draw or paint a portrait. If someone commissions you for that, they pay you for it, they automatically own the copyright in that. Obviously, you can contract out of it, but in most of these cases, they won't allow you to contract out of it, but there is the option to contract out of it. How far am I now? Okay, almost there. What happens when someone buys your work? What are you actually selling? You're selling a physical object. You're selling a photo, you're selling a painting, you're selling a book. You're not selling your copyright. You're not selling any rights in your work. So the person who buys your work can't now suddenly go copy it, adapt it. All they can do is on-sell it. They don't have your rights as the copyright holder unless you have agreed to transfer your copyright to them. So that's very important. Especially if you are selling, for example, digital art on social media or online. Be very clear in your terms and conditions what people can do with your art. Don't leave any room for any type of implied license. Be clear. You can use my digital art for your personal use. You can't use it to make it part of your brand, put it on a t-shirt and sell it. Be extremely clear when you are selling your art, because you need to protect your copyright at all points. It's yours, you need to protect it. So with this comes the question of moral rights. What happens to my moral rights? Moral rights and copyright are completely separate. Even though moral rights, it's the same duration as copyright, but it's completely separate. Moral rights attaches to the initial creator or author. So even if you are no longer the copyright holder, if you've transferred your copyright or you've assigned it, you still have your moral rights. And your moral right means that you can claim authorship of your work, and you can object to anyone modifying it in a way that would harm your reputation. You can't sell moral rights, you can't transfer moral rights, you can, however, waive it in certain circumstances. So a lot of the times you'll see if movies or broadcasts or television want to use your work, they normally ask you to waive your moral rights. So just read that in the contract, it will be somewhere there. How do we transfer copyright? So now Megan told you verbal contracts are enforceable, not for copyright assignment. If you want to assign your copyright or transfer your copyright, it needs to be explicit in writing. And it needs to be signed wet ink on paper. You can't assign copyright verbally, you can't assign it over an email, you can't assign it if you have a contract and it's digitally signed. Written, wet ink on paper, that's the only way that you can assign your copyright. And lastly, when we are talking about selling, we need to talk about royalties. So at the moment, our Copyright Act only deals with royalties for sound recordings and music. It doesn't specifically deal with royalties for literary work or artwork. But a lot of the auction houses are doing this royalty scheme where they do enter into agreements with artists to give them royalties for first sale or secondary sale in the secondary market. So essentially, if you want royalties now, you need to enter into an agreement and make sure that royalties are built in there. This might, however, change very soon once we get this copyright amendment bill through, because the copyright amendment bill will make it compulsory, royalties for artwork and literary work. So, but at the moment, if you want royalties, enter into an agreement. So, how do we protect your work? This should be, I'm probably saying things you already know, but add your name to it. Add a date, a copy symbol, add a copyright notice, a logo, a watermark, anything that you can do to make sure you're protecting your copyright. I know some artists make deliberate mistakes in their work, which identifies them as the author. Most importantly, keep record of how you created the work. Record evidence of the process. This is important to show that you didn't infringe someone else's copyright when you made your original work. So whether this is draft sketches, your first draft words, pictures of how your painting progressed, anything that shows the progression. Which brings us to the next topic of copyright infringement. So I call it remixing. I know there's this high-level acceptance in the art world where you can use someone else's source image or work and create your own original work that has a completely different meaning. But we need to be extremely careful, because I've already mentioned adaptation. The moment you adapt someone's work or make a small change to their work, and the original or substantial features are still there, you are infringing on their copyright. You can't just make a small change. For example, you can't take a photo, make it black and white, and I'll claim it as yours. It doesn't work like that. What level of effort, skill, and time went into doing that, into creating that original work? And the Copyright Act is very clear that work, even if original, that is created from infringed work, it's not copyrightable. You won't have copyright in that. What you can do, you can be inspired by someone's work, you can attribute to someone's work, but it will always be the smart thing to do to credit the original creator or the original author. Because we need to avoid copyright infringement. How do we do that? We get the permission of the copyright holder before we include their work in ours. If the work is in the public domain and there's no copyright attached to it, then it's free to use. You can do with that what you want. If we are talking about open source images or open source work, be careful to read the license terms and conditions. You might be able to use that open source image on your website, but you might not be able to add it to your work. You might not be able to adapt it. Be very careful to read the license terms and conditions and make sure you're not accidentally infringing on someone's copyright. And then enforcement and remedies. For copyright infringement, if you are faced with copyright infringement, you can take legal action. What this normally means is that we would send a letter of demand or a cease and desist letter to the person infringing on your copyright, ask them take it down, please, if it's on social media, get it taken down at the gallery. You can claim damages, as Megan talked about earlier. If that doesn't work, you're going to have to take some more formal legal steps, which includes maybe an interdict application or issue a summons for damages, but that does get a little bit costly. So as much as you can, rather protect your work and instead of letting someone copy it, if that makes sense. And then lastly, just a comment on social media. In the digital age that we live in now, I know social media is your biggest marketplace. That's where people see your work. That's where you get the most eyes on your work. The problem with that is it also leaves you open to the risk of copyright infringement. Someone will screenshot it, post it to their own social media without tagging you, maybe print it from social media and do other things with it, adapt it, add little things to it. It does leave you open to that. So it is a risk that you need to take. You need to weigh up the pros and the cons there. If you are posting your work on social media, make sure you copyright it. Make sure your name is on there. Even if you need to post a lower resolution picture that they can't as easily do something with. Do everything you can to make sure that it's clear that it's yours. Now the next question from that is, can I put someone on blast if they do copy my work? Technically, yes, you can. Just be careful, because the first thing they're going to say is defamation, harassment. To get out of defamation, it needs to be the truth and it needs to be in the public interest, both. Not just the truth and public interest. So the gray area here is you might have the facts that someone copied your work, but be careful about the wording. Having the fact that someone copied my work and calling someone a disgusting snake or something like that, that's completely different, because then you're venturing into defamation. So even though you have the right to obviously say that someone has been copied your work, be careful about your wording. And the same goes for the art that you create. Your art might be defamatory, especially if you're doing art about political figures or political parties. They might see what you're doing as defamatory. So yes, we all have the right, freedom of expression, freedom of creativity, artistic creativity, freedom to do what we want. But all of those rights in the Constitution can be limited. You need to weigh up the interests of both parties. So just a cautionary note in that sense, to just be careful. And then to cap it all off, I think everything that I've said, or a lot of what I've said now, might change when the Copyright Amendment Bill becomes law. They are thinking about bringing in required contractual standard terms in the art space between galleries and artists, between commissioners and artists. So a lot of the landscape might change in the future, and then we'll have another workshop and we talk about all of this again. But for now, this is the basics for copyright and for intellectual property in your world. Thank you.